Paula, for such a lovely introduction. So as Paula mentioned, today I'm just going to be presenting on a couple of cases which I've picked up over the last year. The trial judge found that the husband had been violent towards the wife and that this sustained violence impacted her, particularly in relation to her contributions to the business. The trial judge referenced the wife's Kennan claim in assessing the contributions and held that this claim justified an uplift of her contributions to reflect this. But for this uplift, the parties' contributions were otherwise roughly equal. Now, those are actual quotes from the judgment. When the trial judge was assessing the Section 75(2) factors, he made an allowance in the wife's favour, having regard to the husband's defective disclosure. The trial judge ultimately assessed the total division as to 61% to the wife and 39% to the husband. And the breakdown of that is contributions were assessed at 55% to the wife, 45% to the husband, and a 6% adjustment was made in the wife's favour when assessing the Section 75(2) factors. This resulted in the wife receiving $880,000 more than the husband. In this case, there was an appeal. The two main issues in appeal, it was actually the wife who appealed in this case. There were two main issues: whether there was an error in the assessment of contributions when considering the Kennan argument, and whether too much weight was given to the husband's defective disclosure when assessing the Section 75(2) factors. The appeal was heard by the full court, and the full court held the following. They held that the trial judge failed to assess the parties' contributions holistically, as is required by the Act, and that the onerous impact of the family violence on the wife's contributions should not have been assessed separately and in isolation. So if I refer you just quickly back to that quote, where it says, just the first one here, where it says, he referenced the Kennan claim in assessing the contributions, and he held that this claim justified an uplift of her contributions to reflect this. And he also said that but for that uplift, the contributions were roughly equal. So the judge had essentially assessed equal contributions, but because of the Kennan claim, that there should be an uplift in the wife's favour. And that methodology of assessment was held to be incorrect. And that is because whilst the Kennan claim is something that is to be considered, it should be considered holistically along with all other contributions, not separately.